you. Judge Meriweather, let me just ask you in my short remaining time here. I think Senator Kennedy was asking you about this case, United States versus Johnson, where you recommended the release of a sexual predator to get medical treatment. Is that right? Do I have the right case?
Senator, I recommended a 21-day, a temporary release for medical treatment after holding multiple hearings and giving the government multiple opportunities to get Mr. Johnston to his appointments, because as I noted in the opinion, I thought the charges were deeply disturbing. I take very seriously the danger to the community, and I found when I balanced the 4 factors that I had to consider under the Bail Reform Act, that it was only his history and characteristics, which was that at the time that issue was before me, he had an urgent need for diagnostic and treatment, cancer treatment,
Let me just say, I'm sorry to interrupt you. I'm almost out of time. I just want to make sure I understand the sequence, because I might, as to my questions on Judge Basis, I might not have the sequencing right. So just, you can correct me here. So I thought the government filed an emergency appeal of your release order, and you were overturned by the D.C. District Judge because, for among other reasons, the predator here had been caught in a sting operation. He'd admitted to sexually abusing his 8-year-old daughter. He had been previously court-martialed for molesting a child when he was in the Air Force. That child was his adopted daughter, and he claimed to have sexually molested other children, and the government thought that releasing him was a terrible idea. The district court agreed with him. Agreed with the government. So I just wonder, in light of all of that, as you look back on it now, do you think it was a bad decision to recommend release for him?
2 things. First, all of the abuse that it was alleged was horrific. The charges that were in front of me did not involve the molestation of his daughter, which I believe had happened 15 years earlier. And my decision was not based solely on the nature of the charges. That's but one of 4 factors that the Bail Reform Act required me to consider. The factual predicate, as I highlighted in that opinion, I found it very challenging to even entertain the idea of releasing someone charged with such heinous crimes, as well as someone who had a history decades earlier of abuse. But I found that his own interest in self-preservation paired with stringent conditions, being under the custody of his wife for a limited period of time and only allowed to leave his home to go to the doctor in order to get the timely cancer treatment that he needed, that despite 3 opportunities he was unable to get through no intent, malicious intent of the government.
Can I just ask, this is it, Mr. Chairman, this is my last question. Can I just ask, I thought that he was getting cancer treatment, but your judgment was he wasn't getting enough or the right kind, but he was getting treatment. Is that not accurate?
No, that was the change between my ruling and the time of the reversal. I gave the government 3 opportunities to take him to the doctor, and I kept him detained despite it. He did not get to the doctor. I ordered him temporarily released so that he could see a cancer specialist, because cancer is a time-sensitive issue, as many of us know, with loved ones who are survivors of cancer. And then the next day, he got to the doctor. Had he been to the doctor, I would not have released him for 21 days. I didn't feel that he needed a specific doctor, which was the facts that were presented to the district judge. It was that he see any doctor so that he could timely have his cancer addressed. Unfortunately, that did not happen before he saw me, so I made the very difficult decision of ordering temporary release under stringent conditions so that could happen. It then happened, and so the need for it no longer existed. Had he seen the doctor before I ruled, I would have denied his motion, and I would have ordered that he remain detained.
Thank you for that explanation, Judge. I just note here in the notes, when you disclosed this